Assalamu alaikum and welcome back to the show. Just in case you've forgotten, our telephone number if you want to ring in and ask us any questions. You have two lawyers for the price of nothing today. So our number is 01274 214 299. Today we're talking about mediation and the effect mediation has on the on legal processes. Now before the break we're talking about mediation and how it can help in marriage breakdown. It can also help in litigation cases. So I'm going to reintroduce you to my guest. My guest is Mas Shah. He's a mediator. He's been a lawyer for many, many years, longer than I have. You're older than me, obviously. And he has a vast amount of knowledge, not just on divorce matters, children's matters, but all types of different kinds of litigation. Now, Maz, I was just asking you during the break, because I know you did immigration before.
That's correct, yes.
And I know you deal with property and things like that, but what made you want to become a mediator?
Well, essentially, I think it's the desperation of people, and once you feel that you could make people's lives better by sitting both people down and try to resolve matters, and I think it's quite rewarding. Because before I used to be in your position where I would just act for the best interests of one party and look out for their interest. And then you'd often be in court in a trial, sat behind a barrister, and all these allegations have been made, and it would be quite sad, because when you've realised that, yes, you've had a big legal aid bill or people that have paid privately and your practice is flourishing and you're doing quite well, but I think that is at a cost. And I identified that is at a cost of just human beings, that if we could sit down together and resolve their issues. And once I got comfortable financially, I decided to retire after 20 years of working in fields like immigration, and I did some criminal law and family law and property, as you mentioned. I decided to offer something back to the community and try to stop people from using the court as their first port of call, or solicitors. And if I could sit down with people and resolve their disputes, sat over a table, and often there's so much conflict that has arisen. People don't like to sit in the same room, so I make arrangements. I can see people at public places or their homes, or even in an office type setting, from business disputes to family disputes.
But before you started all of this, did you have to have any specific experience or training? Or, for example, were you given any training, or did you have to go on training courses to deal with domestic violence cases, for example?
Well, as a start, as you know, that I have a degree in law and I practice law. But mediators don't necessarily need any relevant qualifications as such. You don't have to be a lawyer or have a law degree to become a mediator. A mediator's role is simply to be an impartial third party, to listen to two people, because the communication has broken down, and if any party can get involved. Now, historically, I think an elder of the family would get together, or mum and dad would sort it out, or the local imam from the masjid will sort it out. So those roles, mediation has always been around. Growing up, we've seen the elders of the community get together and resolve disputes. It's more so in the last 30 years that we've seen Asian solicitors crop up who are bilingual, who can speak the language, and can attract that migrant community to come and ask for legal help. Whereas before, they'd go see the local masjid imam, or they'd speak to their community leader, or I've heard cases where people have gone to the local councillor and said, look, we've got this issue, can you help us? Because they're within the community. So as you know, that we are, as a community, we've evolved considerably, and we are now in the modern, everyone's using the modern means of communication.
Yeah, you're absolutely right. Growing up, if anybody ever had an issue, they would get the family round.
Yeah.
Whether it's the husband or the wife, they would call in the in-laws, the aunties or the uncles, and they would resolve these things. But I also think that to some extent that kind of system is changing as people become a little bit more isolated. But before the break, I was asking you about how you deal with mediation for domestic violence cases, and you said that normally it's the man that comes to see you and he will say that there's been allegations of domestic violence. So he's coming to you for your help. So in that kind of situation, he's instructed you, you're the mediator, you're saying that you can't take sides. So you would contact the wife, for example. But then what would happen after that?
Well, sometimes they've been involved or are still in the process of going through the court proceedings.
So these two things will happen at the same time, mediation and the legal process.
So they've realised that this matter's been going on for so many years, and they're still, arguments are still being had, experts are being instructed, transcripts are being had, one party doesn't like the outcome of one, there's appeals being going on. So there'll come a point where often the guy who's wanting to see his children would come and say, can you assist? And I would fire off an email or write a letter to the other party saying that, is there a possibility of having a free consultation with a view of trying to resolve your issues. Now, so
that's non-aggressive and non-adversarial, whereas if it was me writing an email, it'd be quite aggressive and adversarial.
Yeah. So by that time, the party to the dispute has realised, well, actually, we haven't got much further either, and the costs that we've had to incur and the costs that have been paid, and they realise sometimes pretty late in the day that whatever they've set out to achieve is now getting dragged out, and they see that neither party is going to win, because at the beginning of the programme I said that the court is not there to take either party's side. They will make an informed opinion, having looked at experts, and sometimes if there are children, they'll have Kafka solicitors, they'll have two sets of solicitors, three sets of solicitors, three sets of barristers. So the court is not there to take a side. They will be making a judgment on their informed opinion based on the facts. So whilst this is all continuing, don't forget the two sets of arguing spouses are still of the view that actually I thought I had a good case and I was going to win, but once they've gone through that process, that early held view is now somewhat confused. So at that stage, people are now more inclined to look at an alternative to resolving the dispute, if for no other reason but to stop the hemorrhage of costs. So at that point, when both sides have had a taste of the legal system and how complicated and how impartial it is, that when they go to court, very rarely do the arguing parties get to speak. They often sit there and they have four sets of well-paid legal people getting paid, and they want to say they want to vocalise and they don't need to speak their problems straight away, but they're often stopped from doing so. So they often sit there on many court appearances when nothing is really said and most of it's all procedural. So they realise that actually court is not the right way to resolve their dispute, and at that point, if I do send an email to them or a letter, that the other party has seen that look, we're not going to achieve anything, we're still going to get dragged along and the end is not in sight. So that's a case where people have gone through litigation and then they come back to mediation, and then often I can assist them with writing a consent order where both parties agree, and often where there are two sets of solicitors, I will simply dictate to either party what they need to go and speak to their solicitor about. I sometimes get their solicitor contacting me, and then they can get an order through the courts that this is how their dispute will be managed. So that's the one part of my job where there are two warring parties. The other is when a problem has just started and that there are children involved. And I often say, look, if you can see, people often forget, and I think it's more so within certain communities, that they feel that the mother has the absolute right of caring for that child.
Most of the times, yes, but not all the times.
Yeah. I often say to both parties is that you have an equal right to your child, subject to if there are other issues of domestic violence, which you've covered in your last program, that if there are any risks associated with a child or the well-being of that child, then clearly mediation is not the way forward. But where there are children involved, it has to be very clearly set out that both parties have an equal right to that child. But often the female in the relationship, or the wife in the relationship, would say, well, it's my child and the child needs me. Well, of course that's correct, but that does not mean that the father can have
no right at
have
all.
no right at all and cannot see the child. So those are the types of situations where if you can impress that on both parties as an impartial third party, and they listen, then they do realise. But often the firm held view is that, oh, it's my child and he didn't have any right to it.
That happens a lot, which is why we end up going to court, applying for child contact proceedings. But one of the things that I should say really is that during domestic violence cases and allegations of domestic violence, one of the first things that happens is the wife or the husband, depending on which party is the aggressor really, can apply for a non-molestation order or an injunction. And what I find is in these kind of cases that happens first. So by the time somebody's come to see me, he will either have had, usually the husband, he will either have had the application for a non-molestation order, which is an injunction, already served on him. So that's the very first thing that happens. And then obviously then you go down the process of whether it's financial or divorce or children's cases, and possibly by that time there may be there's scope for mediation. But sometimes when there is domestic violence, that is the first thing that happens. So I suppose in that respect, I don't think there's really much space for mediation, because at that point it's so far gone. The lawyers are involved, an emergency application may have been made, and that may be made within the first a day or two of that party going to see the solicitor. So mediation, I guess, in that respect won't work. But just changing the subject slightly, I've been involved in a commercial litigation case where one party owed the other £300,000, and the other party said, I don't need to pay this for X, Y, and Z reasons. And I was involved in a full day mediation, and it was really interesting because you're absolutely right, the mediator will not take sides. So both parties will first of all start off the mediation setting out what the issues are, and then both parties will go to separate rooms in the building where they can't really see each other and they can't look at each other or try to intimidate each other. But the mediator is really good, because the mediator will say, I'm not interested in the facts of the case.
Yes.
How can we resolve this? So one party will say, well, he owes me 300,000, and the other party will say, I owe 0. So how do you get those two parties coming to some common ground? And I've actually seen it myself. This mediator, it took, I think, about 7 hours. We were locked in until there was a resolution. And this mediator said, okay, well, if you're going to continue this in court, how much is it going to cost you? 5, 10, 15, 20,000 pounds. Can't you come down a little bit? And so then my client would come down a little bit, and then he'd go to the other party who starts off at 0, and they'll say, well, no, I don't want to pay because I haven't done anything wrong and I don't owe this money. And he'll say the same thing to them, well, if you want to defend this, how much are you going to pay in defending this? And can't you just move a little bit? And again, not taking sides, not looking at the facts. The whole point is, how can you get two parties who are on completely separate sides to some common ground? And I think that's really an art.
Well, yeah, I think, like you've emphasised the point, that if a mediator starts to take sides, it's often, it's not productive whatsoever to the end result. The end result is getting the parties over the line. And yes, I have to listen to what the parties have to say, but that is in a confidential setting.
Well, that was going to be my next question to you. You've got two people on opposite sides, you're in the middle. How do you maintain that confidentiality? How do you gain both parties' trust?
Well, at the outset, this is made clear that any discussions that are had between the two parties remains confidential, because if there isn't confidentiality in what you do, then basically you can't achieve the objective.
Do you get them to sign a document when they first come in and start?
Yes, of course.
Behaviour, rules, confidentiality.
Well, yeah, I emphasise the fact that mediation is voluntary. So people are there because they want the matter resolving. That's absolute. Secondly, I'm not there to provide them any legal advice. They're free to seek legal advice at any stage of the mediation. Mediation can be terminated. There'll be a legal issue that crops up and they want to take some advice. I often stop that and say, look, go seek some independent legal advice and come back and see if you want to carry on the process. So I've had cases where I have stopped mediation and let the other party go away, seek some advice and come back, because my role is to be the facilitator of that dispute, because clearly the two parties cannot sit together and resolve their differences between themselves. So I do not offer any legal advice, because clearly there's going to be a conflict of interest if one party to the other. My job is to simply listen to both parties and to remain impartial and to be objective, because like you've just said, that if you can give the parties at the very beginning an insight as to what they're going to get themselves into in the legal process, then they will be very quick to make their mind up as to how quickly they want the matter resolving. And often in financial disputes, businessmen often feel that actually, you know, I often give people both the worst case scenario, that how sure are you that you can win?
There's always a litigation risk.
I'm not sure. Well, how sure do you think? Are you 50% sure? Are you 60% confident? Well, yes, there is still that 40% risk, even though you feel that you have a good case. But if you feel that mediation can't achieve that, you can always go seek some legal advice and see what their opinion is. And I often encourage that in a dispute like that, that they see a solicitor, and the solicitor can often get a barrister's opinion on that. And that will remain confidential to that party, and say, well, if you feel that you have a very strong case and you want to litigate, by all means mediation is not good for you. But if you come back and you've only got a 60% chance, then the other party still has a 40% chance. So when you start to analyse the pure facts and look at it objectively, and that fear of losing the money or still having to pick up the legal bill and go through all of the time that's wasted and the relationship that you've lost, that you could quite easily sit down and both walk away as winners, rather than one person feeling that he or she is at a loss.
See, that legal bill that you just talked about, if it's something like a commercial litigation, if it's a business dispute, for example, it could be 40, 50, 60,000 pounds. And if one party, no party can ever be 100% sure that they're going to win, even though they may have a very good case. It may be the case that they have a bad day, the judge doesn't like them, something isn't consistent in the witness statement, they may not be able to give evidence properly, they may not be credible. So the fear of having to pick up the other party's legal cost in itself should be enough to say, I'd rather mediate and pay £500, £3,000 for the day and mediate that, than running the risk of spending the next 10 months in litigation, getting to the final hearing. You lose that because somewhere along the line you've not come across as well as you thought, or the other solicitor or the other barrister undermines you and ruins your credibility, which will then make you look very weak in front of the judge. And even if you think that you've got a very good case, no barrister is ever going to say you've got 100% chances of succeeding. I've never, in my 27-year experience, ever had barrister's advice where the barrister say, yes, 100% you're going to win this. Because people just don't do it.
Sadly, that is not communicated to the client at the outset, because clients
are so fired up at that point.
Yeah, so if the client was told that at the outset, he or she may make that informed opinion. What happens is solicitors are often guilty of just carrying out their instructions, because unfortunately we live in a world where, you know, solicitors are tainted with the view of driving expensive cars and charging lots of money to their clients.
That is so unfair on solicitors.
So they wouldn't be able to make the money if they were to get a resolution at the very outset, and that's where it comes back to mediation, that I'm in a position where I can say, take legal advice at any stage of the process that I offer. I often send parties away, they're on that point, and then they can move forward, because clearly it is, like you said, it's a risky affair, especially for businessmen, and disputes in a civil matter can rise into the thousands.
Well, one of the things I've never said to my clients is go for mediation apart from divorce matters where they have to go to mediation.
Yeah.
Well, the court encourages them to go to mediation beforehand. But I do say to my clients, look, I would rather you resolve this between yourselves, then come back to me. And if you can't resolve it, then obviously I will go ahead and do what I'm told to do, what I'm trained to do. But I honestly do feel for clients, especially when you've got ordinary working class people who work really hard and they've built up a small pot of savings, and to see that should be spent on solicitors or barristers when there is another route for them is really sad for me to see as well. So honestly, after this, I'm actually going to take your number and tell more of my clients, go see Maz and try to resolve whatever issue it is, whether it's children or divorce or financial or any kind of dispute. They need to go to see a mediator before they come back to me. So I'm going to try to make it a point that I do this. We've got literally about a minute left. Can you tell me in about 15 seconds if you've got any really good success stories where mediation has really worked? Well,
I think we've got time constraints. It's been interesting. I hope to be invited again on another programme where we could take...
Do you not have any success stories for me? You can't think of one just off the top?
Essentially, I'm minded not to involve
confidentiality.
Yes, because I don't want someone saying, "Oh, that was my case," and so
I will let you off.
I'd rather leave it at that. But yes, absolutely. As a final point that I'd like to make is that this is my way of assisting the community, and it's my charitable input in the community, and that's why I actually decided to do mediation rather than carry on the legal path.
Thank you, Maz.
Thank you for having me.
So thank you very much for being on the show today. I hope the viewers have found it interesting. I have definitely found it interesting. If you have any questions, please ring the control room, and inshallah I will see you again next week. Thank you for watching.